Have you communicated with a social media user who goes by the name ThATuMBRELLAgUY?
I've had several phone calls with the person who goes by the name ThATuMBRELLAgUY. I don't actually know his real name.
And unfortunately, every time I make a call, it becomes content for them idiots.
Help! I've been tossed overboard.
I'll have to bill you extra for my time.
Welcome to the show. You look incredible, like a dessert that owns a yacht.
That's exactly the vibe I was going for. You know, sweet but slightly out of your tax bracket.
Mission accomplished. How does one even shop for a suit when your head is...
Gold on my neck, gold on my hand, purple with the stripes, that's the walk of a man. Sidewalk shining, city lights humming, every step I take they know a boss is coming.
Is that a poppy seed? You realize I'm your P.O., right? Straight to booking!
Police or zombie problems? Your tortoise won't stop breakdancing?
Try blue tape.
The miracle of our age. Yay!
Hey, we love that umbrella guy. All right. Thank you.
I'm calling from Los Angeles, and I'm having a little problem under the name ThATuMBRELLAgUy. I sent him my phone number at least 20 times in the chat and told him to call me. He ignored me. I'm a man. I filed the report. If you guys could take a look at it and give me a call back, I would love to hear what you guys can do to help us. We really need to kind of stop this guy at least until Monday. I told him to call me. I'm a man.
You know what? I talk to your mayor.
Yeah, it's T.U.G. That umbrella guy. You picked the wrong storm. 2 times on the docket. Used to lane learn. You kept running to the court. I just let it burn. You was barking on the phone. All that tough talk threatened. Now you looking at the floor like judge. I'm just stressing. You swing wild. I bury that. Turn it to a meme. You gamble with your rep. I'm cashing out on the stream. You said you'd end me. Now you trim me. You a car crash clip. I rewind it in 4K HD. You hate the channel cause the truth don't bend. You ain't a rival. You a cautionary tale I pen. You said you wrecked me, but I wrecked you worse. You tried to cancel, now you stuck replaying this verse. 2 times ain't enough for you. Keep suing cause you're scared of truth. That umbrella guy gon' shine right through. You call it war, I call it views. She crazy, 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 crazy. Yeah, that's old news. Crazy, crazy, yeah, that's old news. 2 times ain't enough for you. Yeah. You was yelling at the screen, veins popping in your neck, talking big, talking bold, but your story don't connect. You a late night rant, I'm a documented fact. You a tantrum in a tweet, I'm receipts in the stack. You said I ruined you, I said bet cool. Now the judge looking sideways, who really the fool? You keep threatening in the dark, I just flipped the switch. You a star of your own breakdown, welcome to the glitch. Mic drop, every time that I quote your lies. You keep spinning, I keep winning, watch the view count rise. You call me villain, but I'm still chilling. You the one scribbling in threads like that's some kind of living. 2 times ain't enough for you. Keep suing cause you scared of truth. That umbrella guy gon' shine right through. You call it war, I call it views. She crazy, 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 crazy. Yeah, that's old news. Crazy, 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 crazy. Yeah, that's old news. 2 times ain't enough for you. 2 times ain't enough for you. 2 times ain't enough for you. You threatened my name, I turned it to fame. You play with the flame, got torched by the game. You keep coming back, same move. times ain't enough. 2 times ain't enough.
What's up, folks? How's it going today? Man, oh man, oh man. I tell you, it has been a really interesting ride for the last few days. You know, Megalodon's foe, she steps away for a minute. So what happens? It starts raining content. Oh my, oh my, oh my. How's everybody doing today? I hope everybody is doing fabulous, by the way. I'm having a great day so far. Tomorrow, like I said too, I am not sure if we will have a live stream or not. I am taking the oldest has been driving me nuts about that movie, The Back Rooms. She wants to go see the movie The Back Rooms. You know, she's like, oh my gosh, I gotta see it. So I told her I would. Today, by the way, we were going to have a Rumble / YouTube party, right? We were going to do both, but unfortunately, Rumble Studios was having some kind of issues. I'm not sure what exactly was going on with it, but I could not get YouTube thumbnail or any thumbnails rather to pop up. I couldn't tell if they were working right. Media wouldn't work right. So you just stuck with us this way today. Man, look at those freaking memberships, by the way. Check that out. 20 memberships, right? Man, 20 membership. Jaguar, thank you. That's awesome, my friend. And on top of that, got Stacy dropped in 10 there too. Man, that's crazy. It's raining memberships at the beginning. I appreciate you folks. Man, it's good to see everybody, by the way. So today we got a good show for you. We actually we've got a new document that dropped in for Fed 2. We have well, as the main showcase predicts, we have Lynette Preston wrecking her own excuse for bankruptcy court. That one was pretty amazing. That one above all. I thought that was amazing. So you want to see that? You want to see her drop in a bombshell right on her own excuses? Because I thought that was something. I was like, man, you know, I've seen somebody do damage to their own excuse making. But my Lord, not like these people are just flagrant about it. I mean, they are just flagrant. So I'm going to show you this post. It's still up, okay? She posted this one day ago, all right? And this just blows her excuses out of the water. It's amazing. She's like, I heard I dodged a deposition again. Nope. The surgical appointment John had was scheduled, I want you to remember a couple of dates, April 28th. For May 27th, John's birthday. April 28th. Well, that's weird. Now, if we go back to the document that they put out for this, you know, the very first document that they put on the record. Oh, man. I mean, right away, they blow away their own excuses. So there's a few things wrong with right off that line. Let's pull this up. Let's showcase this. Let's just get it rolling right here. So in this document here, this would be Doc 121, the one that was filed on 5/25/2026. Entitled Debtor's Emergency Motion for Protective Order regarding deposition and incorporated memorandum of law. They go through the background of we don't want to show up because. Now, right here, number 6, I want you to notice something here. Mr. Cook is scheduled to undergo a medical procedure on May 27, 2026, which was arranged months in advance. April 28th is not months in advance. In fact, April 28th is a day you may remember, because that is the day that they were supposed to have everything situated and scheduled. What it really looks like, first of all, I mean, that's an absolute lie. Months in advance, she just blew that out of the water. She blew that absolutely out of the freaking water. In fact, the day they went and scheduled this bullshit is the day, you can see this, by the way, what I'm going to show you as Exhibit A. What they did is they went out, it looks like, and they scheduled something on the exact day that they found out they were going, they found out about the date. So check this out. Here, this is the document 121-1 that was that this is Exhibit A attachment. It attaches the notice of taking deposition of Lynette Preston. So it talks about when that was going to happen, you know, on May 27th, 2026. It was going to happen at 8 o'clock. Check out the date that this was situated. It was delivered on April 28th, 2026. Huh, you mean the same day that Lynette Preston and John Cook, they suddenly had this this issue pop up. Huh. That's interesting. So again, their lawyer approaches the court and says, actually, Your Honor, we scheduled this thing months in advance. But the reality is it was scheduled on the day that they ended up with this, according to her own post. It also, Lynette, is that a surgical procedure or is that a pain management procedure? I'm curious because, well, just curious about that. Here, let's go back to this, though. Isn't that interesting, though? I mean, that's one hell of a lie. That is one hell of a lie. Also, a bigger lie in this is the idea that they didn't confirm dates. Oh, my God. Again, they even bring up the date in a hearing, which is noted in their exchange. She's like, we don't celebrate birthdays, so it's the perfect day for him to relax after his procedure. Yeah, the only day, as John Cook himself noted, it was the only day of the month when they planned something. Huh. And they planned it on the day that they were supposed to have a hearing. Again, their own document. Lynette, you disproved your own document. Congratulations on that. It's just amazing. You went out to do damage control, and your damage control, it undoes that itself. When does truth matter, these idiots? Well, when indeed. when indeed. I swear. I know. Hey, by the way, all of you wonderful folks out there, much love to you. Like I said, you know that when Megan's away, the manna from heaven, it rains down. That's what happens, right? That's what's happening right now. If you're like, man, where's all this stuff happening? Where's it coming from? It's because Megan's away, you know? I like how they're like, vet your information. Sheesh. Who wrote this for you, Lynette? Vet your information. Just saying, just saying. Oh, my God. Vet your information. Oh, my God. We see what you posted yourself, lady. You know, this is funny, too. So, Vomit and Paint Chips had a little cry-a-thon on YouTube, too. That umbrella guy called me out about getting a woman jailed. He blamed me. It's not my fault. Do you think she blames me? Oh my God, what a loser. He wrote an article about getting some lady jailed for 3 days for leaking some sensitive material. And then he's like, Mean old Tug, he blamed me. He didn't read 400 of my articles that I'm sure she had to pay for. Oh, gee. Oh, fun times. Oh, Lord. Imagine getting somebody jailed and then crying about it. You write an article about how you got them jailed, and then you cry about it when somebody else brings it up. Oh my God, this mean guy, he blamed me when I said in my article that me leaking, he got her jailed. I mean, yeah. Sorry. Okay, so it's taking me a minute. What an idiot. I mean, these people, man. They amaze me sometimes. Anybody that pays them, Lordy, what kind of fool are you? I mean, why would you give these people money? Oh, Lord. So let's continue. Shockit did not confirm the date with my attorney. It didn't confirm the date with my attorney. Well, as they noted in the exhibit, I believe it was Exhibit B, in the discussion there, yeah, they even talked about it. Let's see. Let's look at the email about this. Here, let's check this out. I love how after the fact, you actually have all of this stuff. But again, these morons will not go and check out any of the information that is in the, I mean, these are her documents, by the way. It's not, just to note this, these are her documents. They don't belong to Hale's. They were posted by her own counsel. So when the inevitable excuses arise saying somehow that it was somebody else that said this or something, there'll be some weird freaking excuse for it. There always is. There's always some inevitably, like I said, weird excuse for it. But you'll notice, again, her lawyer put this on the record. And it notes straight up, if her lawyer didn't check with her, that's actually not anyone else's problem. But as far as the date is concerned, I mean, you can see them talking about it right here. They say, yeah, not only did we bring it up, but we brought it up in a court status conference. So this was coordinated over the phone weeks ago between myself and Mr. Saran Wrap. And also, this depot date told to the court at the last status conference with everyone present. There were no objections. No objections were made. So they threw it in there. It sounds like they ended up pulling kind of a fast one on that. And again, they didn't have an emergency. Now, will they get away with it? Maybe. Maybe not. You just don't know. You never know. But the wild thing isn't whether they'll get away with it or not. It's the fact that they're lying about setting it up and scheduling it. And as Randy's saying here, he's like, look, they keep doing this stuff. This isn't the first time. They have a history of like no showing. And their excuses were, well, we're trying to be convenient about it. We're trying to do this. Now it's funny though. She's like, when she's talking about this, talking about her no show, she's saying through this whole thing, I heard I dodged a depot. Well, you absolutely did dodge the depot. You didn't show up. Did the judge decide on your excuse? Did the judge say, yeah, you're excused from this? You don't have to show up. Did they say that? No, they absolutely didn't. They didn't say anything about that at all. They didn't tell you, hey, you don't have to be here. The judge didn't make a ruling on it. When the judge didn't make a ruling on it, that means, what is that thing? Oh, yeah, there's no ruling. I mean, my God. it kills me when you see this stuff because, again, they don't wait for the judge to make a ruling. They just decided not to go. They were like, "Oh, we have this issue, and by the way, other people are to blame for it." As always, it's always somebody else that's to blame for the issues that are caused. It just blows my mind. So she said, "Didn't confirm the date with my attorney. My attorney told the courts I could not be there." Now, actually, your attorney put in 2 emergency requests so you wouldn't have to be there. That doesn't mean that the court said it's okay that you aren't there. There's a big difference. Your attorney can tell the court anything, but that doesn't say, yeah, you don't have to do it. But you notice this too. So here's a fuck up. As I'm John's driver. As I'm John's driver. So her first excuse here isn't about child care. It's about her being John's driver. Now, to me, that's a really telling portion of it too, because again, the background of it, the reason that they approach this not from a medical standpoint, but rather from a fragile child standpoint, is because John isn't part of the bankruptcy. So they approached it as she's going to be unavailable due to avoidable caregiving obligations involving her special needs kid. It's not about him. It's he requires transportation. Well, with all the sensitivity he deserves, fuck him. It's not his setup. And if this were only one thing, that would be different. But again, every time they have something come up, there is some type of, oh, can't do this, can't make it, can't. I mean, that's how it goes every single time. Remember all of the stupid that happened. I think the thumbnail case is probably your best bet with it, but it's not the only one. I mean, you go back years with these people, and there's been plenty of these. Plenty of them where they're like, I can't show up, not going to show up. And I mean, the bankruptcy thing, you got to remember all of this. This is the set of hearings that they were so proud of. They were absolutely proud to have. But when they talk about this again, you got to remember they're not allowed to just say, well, I can't make it because John cooked. That wouldn't fly. Again, that's why they didn't use that excuse. But you notice that is her first thing that she pulls out of that. She's like, I'm his driver. Well, like I said, with all the respect that he totally deserves in this, he could get himself another fucking driver. He absolutely could go find himself another driver. I could use any other serve, but I don't. Again, so they schedule an appointment on the day that the stuff is supposed to happen. On the day that comes out, they go and they whip them up an appointment that freaking day. And then try to say, oh, well, we set it up months in advance. I mean, again, Lynette, you just blew up your own excuse. You blew up your own court document here. Now, will anything happen with that? Who knows? I put no faith in anything ever happening with what these people do. But I still like to call out their bullshit because again, this is just, it's her words. It's her lawyer's words. So she doesn't like what's stated there. Well, maybe they shouldn't state it that way. If she's like, oh, well, that's not correct. Well, then, who filed this paper? Did I file it? No. It just amazes me. So she's like, and he can't chase Harley around today. So I had no one to take care of her. But you notice his, the first excuse there isn't a child care excuse. It's a driving excuse. I just, you know, they pretend. So down the road, let me understand this again. So the guy, I mean, she said some pretty awful things with Cook. There's actually a nice voice clip. Mark brought up one of the Shara voice clips where she's talking about John Cook, and she's talking about distancing herself from John Cook. I mean, there's so many of them. They're everywhere. We have yet another one. I can't even keep up with how many of them are out there, but we have another one. How about where she's talking about, yeah, I'm distancing, and me and the baby are going to leave this guy, because he's supposed to be a monster. Actually, let me see if I can bring that up. I'm going to bring up the clipto for that real quick, Mark. Since you posted it, you can actually hear it. Here, check this out. See, I love these because, again, these are her own words for. Yeah, this was to Shara. Check it out. It's only about a minute long. Let's see.
And I don't have any friends. I don't have people I can confide in because every time I do, they turn to Hales. Everything I say goes right back to him. So I'm alone with just me and my child and my sister. My sister's too afraid to say, John abuses you. And I'm not going to put up with it anymore. I am going to just distance myself and Harley from John. And we're not going to be around him anymore. I will be doing a video.
You noticed that there. So I'm alone with just me and my sister, or my child and my sister. My sister's too afraid to say John abuses you. And I'm not going to put up with it anymore. I'm going to just distance myself and the kid from John. We're not going to be around him anymore. So we go from statements like that over and over again to, oh yeah, John's the only person. He's the only person that can ever do anything. Again, they have, can anyone verify if LP's bankruptcy? No, it has not been dismissed. There was an old video. So apparently what happened was somebody saw an old video. And with the old video, it was talking about, remember there were 2 bankruptcy procedures. Remember? There was bankruptcy 1 and it did get dismissed. So what I think happened is somebody accidentally pulled up a YouTube will show you old videos sometimes just out of the blue. There's no rhyme or reason to it. It'll just randomly throw one in your face, right? Oh, you like this channel? Well, here you go. And what I think happened is somebody noted that Hales had put up a video stating that the bankruptcy had been dismissed. Well, the only videos with that are, like I said, it's an old video. So they just probably saw an old one and they thought the bankruptcy had been dismissed, but it hasn't been. It's still rolling. We still rolling rock, So if it had been dismissed, they would, they'd be saying that. What are we congratulating? Hey, what are we congratulating? I see all the congratulations. I'm not sure what's congratulating. Photo lady, what happened? Oh, here it is. Hey, I'm so excited to announce, the birth of my great-granddaughter. Oh, that's awesome. That is awesome. I love you. Yeah, congrats in the chats. I appreciate you telling us about that. I love it. I love it. I love the fact that it's not just that special thing, but we get to share it with people. So I love that. Thank you for sharing that with us. I saw the congrats rolling through. I was like, what's everybody congratulating? I always love good, we we see a lot of bad news too. So I always love it when we get some good news there. But then she says, I had given several other days I could do the depot. Yeah, they gave several other days after the fact. So they didn't, again, when they schedule this and they provide a document on the 28th, the same day that she is told that, again, if she's saying there's miscommunication, that's on your fucking lawyers, lady. Your lawyers are not doing their job. Their job is to inform, because she was saying something the other day that just blew my mind in many ways. She was over on the 2L channel in comments, and she was like, well, if I don't see it here, I don't find out anything about my case. And first of all, that's pretty pathetic, because these people, remember who talked you into a bankruptcy. You know, you're sitting here potentially losing part of what you have. And they told you it was the greatest move ever. You wouldn't lose. Remember, this stuff has gone from you're going to make millions to, well, hopefully you can keep from losing it all. I'm sure that is not when all of this was starting up, you were thinking, man, I hope I don't lose my property. I know that wasn't what you were posting about back when. So to say that, period, it blows my mind. But on top of it, that's an indictment against your lawyers, because you're saying that you are not finding out about your own cases from your lawyers. They're not informing you about hearing dates and more. See, they knew about this. They knew about it for sure. Not only did they coordinate it, but they had a document noting that date, and you didn't roll back around until the 15th of May to say anything about it. So you're telling me that your lawyers, they didn't communicate this to you? And somehow that's the opposing counsel's fault, by the way. Your lawyers are supposed to tell you about any meeting that comes up. In fact, the majority, they will either contact you, or if your lawyers don't call you, they should be sending you something that confirms any date that comes up. And if you're not keeping up with your own cases too, what the fuck, man? I mean, I can't even imagine not taking my own cases seriously enough not to stay informed. And I'd be riding in the law. I would. I'd be like Mike Tyson Punch Out if they were freaking telling me my stuff. They're like, well, I gave more, but Shuggy refused to schedule it on a day I was available. Just like all the other times. Like all the other times now. You notice that? Your last time that you pulled this, you pulled it on the last second. The last day. I've watched it. See, this spin may work for people who don't keep up with any of this whatsoever. But the last time that you pulled the doctor, or, the John doctor excuse thing, you didn't note that until the very last day. You were supposed to be in the next day. And you turned around and said, nope, got a doctor's. John's got a doctor's thing. And we can't make that work for us. So for you to say, like all the other times too, what a bunch of bullshit. I mean, again, that was very, very easy to go look up. And a lot of people watched that play out. But there's this hope. Again, to just say shit and people should believe it. All these folks, man. All of them. That's their MO. They just say something and you're supposed to believe it. All the other times, stop believing the lies. Stop believing the lies. I'm still here waiting on John's procedure to be finished to take him home. Vet your information. Oh, we do. We vet it through court documents and more. Did you have a depot that you were supposed to show up for? Absolutely. Did you, again, schedule something on the 28th and yet say that you had it scheduled for months? Absolutely. I mean, when you go in and look at it, you tell us to vet our information. But the information that you provided, we can easily vet against what you provided. That kills me. Vet your info. Well, we did. We absolutely did. She also posted something else I thought was interesting about projects. Give me a second. Again, I'm referencing these right from where they're coming from. It's funny. The strange games that are played. So she's talking about, this one was posted just a few hours ago, by the way. So check this out. I think you'll enjoy this one too. Look at all those giftos, man. That is awesome. Like I said, the beautiful thing about gifted memberships is it doesn't just help the channel. It tells people, hey, you're part of this and we appreciate you. I love that. I love them. I think they're cool. I think they're one of the coolest features on the platforms, any platform, because they give to other folks and they're like, hey, you too, you're part of this. I just think that's awesome. So thank you, folks. But here she's talking about it and standing in the truth. Oh my God, I got a little bit of truth on my shoe. Gross. So much going on here in Otter Creek. Working with an engineer to get the house on track. Working with an engineer, you say? Well, that's weird. With what money? With what money exactly? You know, what's really funny, again, if they're playing the money game, aren't they supposed to report any type of fundage that comes up whatsoever? Not only that, but in the middle of a bankruptcy, that seems very strange. So you're you're in the middle of something where you should be shutting down anything, and yet you're talking about how, well, actually, yeah, I got this going on. It's just kind of weird, don't you think? So she's saying that they're doing work, you know, again, with what money? It's funny too, when they say stuff like this, what does it even mean anymore? You know, what does any of it mean anymore? I always like, wait a minute. You can't believe a word any of these people say. So are they actually doing any work? And again, what are they doing it with? So she says that, and it's so quiet now, except for the crap across the street. Except for the crap. She's talking about Travis, by the way. You notice they go out, they gaslight Travis all the time. And then somehow, in some way, they're going to bring Travis up again. That's what this is. I thought they were talking about Jeremy at first, but I believe they are talking about Travis. It's hard to tell. They mix them together. Sometimes I don't even know if they know what the fuck they're talking about. But it is amazing. I mean, they can go out, they can start shit with somebody, and then they play the victim, as always. You know, they're always doing this, though. You see Travis is he out there attacking them and doing anything? No, they're like, it's funny. He claims we do all these things to him. Yet when we walk out and he sees us, he yells over to us, or he says hate-filled lies on his channel. Talk about obsession, man. They obsess over Travis. I mean, it's wild, isn't it? When I see stuff like that, it's like, what? Yeah, exactly. Screenshot this. Travis is so unproblematic. Exactly. So it shows how evil they are. Yeah, indeed. I just that's funny. Cheese on my feet. So many people are like, "Is that say?" It says J's on my feet, but it's funny. People are like, "That says cheese on my feet." Now, sometimes I sing it as cheese on my feet too. After so many people have said it, it's cheese on my feet. The cheese on my feet song. Cheese on my feet, indeed. Oh Lord, you crazy folks. Cheese on my feet. Ugh. So she continues by saying that it's so sad. We can't just have total peace here and peace of heart and mind. Huh. You remember these folks burning trash and then bragging about how they were going to, the next time that they burned trash, that it it was going to smoke all the other people around out. Remember that? Does that sound like you're seeking peace? I'm just curious about that. How exactly does peace and tranquility come into that statement? Because you know they talk this game about how, yeah, all we want is this or all we want is that, and yet when you get down to it, the actions they definitely they don't display the same thing. It just kind of blows my mind, you know. You'll see them; they'll be talking about, oh yeah, we just want calm, we just want peace, but by the time to get a lot done here, we have a bunch of can holders, etc., etc. You know, all this, they could have just led with all this stuff right here, right? And talked about water, but they didn't. They didn't. Instead, they go into all this shit about, you know, Travis. Travis is the monster. And we're trying to work on this thing that's over here. Again, is somebody finally going to cough up a few of those dollary dues? Are you going to actually audit how much money they give, if they give you anything at all? How's that going to work out? You know, again, 496.411, 496.413. Look them up. Look them up. They should have been her money. But that came up. Now today we got a Fed 2 filing, which was actually quite interesting to say. I've not read either, but it is the plaintiff response to paint chips. So paint chips is, I want to dismiss this thing. Well, let me see. There's a lot of pages. Are there exhibits in here, or is it all just, there's a 30-page document. Give me a minute. I'm trying to see how much of this in this is the main document. It's all, wow. It is absolutely all the main document. So that's interesting. You know, hey, instead of a less is more approach, you get a everything here is approach. So this, again, this is the answer for Hale's for paint chips and him trying to dismiss the third amended complaint. Remember, if you haven't been keeping up with what has happened in Fed 2, you started out with 10 people. 10 people was trimmed down. There's also another set of filings I still haven't gotten to yet. They just popped up as well. They are him and his attorney asking for more time so they can file about fees. You know, they're saying, hey, we are entitled to lawyer fees because they honestly, out of anybody, they would be, if anybody has an argument, they would be the only party with an argument because they approached with anti-slap. But there's questions over whether they actually, since they're in a federal case, if they can do that. And on top of it, there is there's the timeline on it. So they're asking for more time to be able to put in an argument for that. That is actually out there as well. This, however, there were two remaining parties that were left engaged in it. There was LMNOP and there was Paint Chips. And this is a response to Paint Chips seeking to have this dismissed. So it notes, defendant Paint Chips seeks dismissal through a procedural smokescreen designed to evade accountability for publishing a sexually explicit video depicting Jeremy Hales engaging in oral with a journalist after evading service for months by providing inconsistent address information and refusing to cooperate despite actual knowledge of the lawsuit. Defendant now, after being defaulted over his objection, attempts to re-challenge the substitute service that his own evasion necessitated. Wow, that was pretty fucking direct, Randy. I like that. Damn, that's hammer time right there. You know, he's like, yo, this guy right here, he puts this video up. This thing right here, it in of itself is a problem. On top of it, he argues this service. We have to go and serve him a different way. And now, even after that's completed, he's sitting in here arguing it again. After creating and publishing a fabricated sexual explicit image to destroy plaintiff's reputation and livelihood as a social media influencer with over 730,000 YouTube subscribers, defendant claims the statute does not apply because the image was manipulated rather than authentic. And after plaintiff pleaded damages exceeding $370,000 based on harm to a substantial social media business, defendant claims the amount and controversy is insufficient. Each argument fails. That's pretty damn blunt, like just straight up. Bam. That's direct and to the point. I like that. See, a lot of times in filings, you'll have people that will engage and they point out the law and how it relates right off the bat. Man, I don't know if it's modern judges or what, but a lot of them, you have to entertain them. It's kind of like Gina Carano. I don't know if any of you saw her lawsuit with Disney. Okay, with her lawsuit, again, she ends up winning her lawsuit. But the way that her lawsuit is put together, it's spicy from go. It actually introduces itself almost as a it's about her working on Star Wars, and it puts in what is essentially a Star Wars scroll at the beginning. It's kind of amazing to see it when it's laid out the way that it is, because it was eye-catching. Well, this too is eye-catching. I think that really, it matters. It speaks there. So substitute service was proper under section 48.181, which authorized service on any person concealing their whereabouts regardless of residency status. Defendant concealed his whereabouts by providing inconsistent addresses, refusing to facilitate service despite direct contact with plaintiff's counsel, and making personal service impossible. Alternatively, the court should grant additional time under under Federal Rule of Civil Procedure 4M because plaintiff showed a good cause through extensive efforts thwarted by defendant's evasion. Defendant suffered no prejudice given his actual notices since August 2025, full participation in this litigation. Now, count 2 adequately states a claim under Florida's sexual cyber harassment statute. The statute's definition of sexually explicit image as any image depicting a person engaging in sexual conduct, broad and unqualified, encompassing manipulated images. A narrow interpretation, excluding edited images, would create an absurd loophole, allowing perpetrators to avoid liability simply by fabricating images. The third amended complaint adequately alleges all statutory elements with sufficient factual support. The court has subject matter contra. Oh, by the way, I thought this was interesting. So, too, one of the things that's really telling about all of these folks when it comes to this, Ray pointed it out to us, the hypocrisy to it. If you say, hey, if this were to happen to, say, your daughter or something, would you agree with that? Would you think that this is right? And he absolutely threw a shit fit about it. He threw an absolute shit fit, saying it was a threat. That tells you that they have a real problem with this. They know it's improper. They know it's something that they themselves would not want pointed, but they're okay with it going towards someone else. Very godly, very good. I saw somebody sent me over a milquetoast video too. I was like, what in the world? He was essentially whining because someone said, hey, respect another person's mental health. And they're like, oh, my mental health. By the way, milquetoast, you're a drama channel. You just did a video about the quartering. You were talking about, do you think like that person's mental health? Do you think you don't impact that at all? But they don't care. We're talking about all that other bullshit about so many other people. Do you think you don't impact theirs? Oh, my Lord. But they're like, oh, can't respect this other person because me. Oh, Lord. I swear, all these people, man. Anyway, continuing. The court has subject matter jurisdiction because count 2 independently satisfies the amount controversy requirement through the combination of statutory damages, actual damages, injunctive relief, and attorney fees. Joinder of both defendants is proper under Rule 20 because both targeted plaintiff's social media business through a coordinated campaign of harassment. Even if joinder weren't proper, Rule 21 expressly provides that misjoinder is not a grounds for dismissal. For these reasons, defendant motion should be denied in its entirety. Statement of facts. Again, Hale's, his 70,000 subscribers, Facebook account, TikTok, Instagram. You've seen this so many times. I'm just skipping that part. Okay. You know what it says. I want you to see that there, though. It's on the screen for you. Paint chips. On or about January 28, 2025, Paint Chips sent an email to the ADL making false statements accusing Mr. Hales of anti-Semitism and comparing him to advocates of eugenics and mass murder. That is very true. On the 26th of January, Paint Chips sent an email to myself making additional false and defamatory statements about Mr. Hales. Have you all seen that email? Have you all ever heard that email, by the way? I'm curious. Have you ever heard, again, in their quote-unquote journalism, have you ever heard what these people, they throw out and they then pretend that it's not a problem at all? I don't know if you ever actually heard what was stated in that. That's the one where he thinks that I'm still married at the time. Like, listen to this. You want to hear his email? I'll read it to you real quick, okay? It's, hey, Matthew Lewis, a.k.a. Louie. I have you, that umbrella guy or tug, and your wife, Ashley, on this email. I'm writing a story about, now he tags in to try to find, he doesn't know the address. My address is easy to find, but that's not what he goes for. He tags in 1, 2, 3, 4, 5, 6, 7, 8, 9 random emails. just so he throws these accusations out to multiple random, who knows who got this stuff. Who knows? All right. He says, I want to give you a chance to counter claims that the both of you are eugenicists and believe in eugenic philosophies in line with a certain dictator with Germany. I would love for you both to go on the record with your side of the story. Story, by the way, you notice that? I know that since Preston and Cook are public figures in your opinion, then both of you must definitely be public figures. Do you believe there is a master race and the philosophy of eugenics is virtuous and moral? Do you support mock journalist Megan Fox's views on eugenics applied to children? Now, her post, by the way, that she had put up that they tried to, it was a post from 2024 talking about idiots eating Tide Pods on TikTok. It said, unpopular opinion, let the kids eat Tide Pods or nutmeg or whatever dumb thing TikTok tells them to. Best if you learn the hard way rather than impose all the safety laws on everyone else with IQs higher than amoebas. Hashtag Darwin Awards. That's the best they could do there. It says, are you anti-Semites? Do you hate Jews? Do you support Hale's version of anti-Semitism? Or is there another version you ascribe to? Do you agree with the political conclusions of, that certain person, that certain dictator's book? Are you, and do you believe that Megan Fox and Jeremy Hales are insensitive to the systematic a murder of 6 million Jews during the Holocaust and anti-Semitic hate that persists to this day when you perpetuate hate by denigrating names called Deuce Foreskin and the Big Nose? Are you willing to apologize for your remarks that many considered offensive? I mean, this guy, you imagine the audacity. Like, this is what they do, though. This is exactly what they do. And the way that you deal with people like this, for myself, is you mock the living shit out of them. That's how you deal with it. But this is the kind of stuff that they mail to places like the ADL. This was their attack. So he goes on from there. But this is the kind of stuff when they talk about mailing. And then on top of it, he also threw in, he went to threaten he threatened to dox some random woman from, because he thought he had the right person. He again thought that was my wife at the time, which that's so dumb because they don't do any research at all. But he's like, do you have any headshots or pictures? The only representation I could find with close to Ashley Lewis was this, so I'm going to run with it. So he's just going to dox some random woman. And then he puts in a bunch of phone numbers because he made sure to try to dox phone numbers too. This is an absolute piece of shit. So anytime, he's been crying about DJ Radis. And DJ Radis making fun of him. And I'm like, wow. Compared to that, DJ Radis is, really? I think I might have a radar in a second. I think it hears me. Hey, close the door, kiddo. Hey, Dad? Yes, ma'am. You know my bed sheets on my bed? Your what? Hey, Dad, you know my bed sheets? Yeah, your bed sheet. What about it? Every time when I sleep one day or go one day. It slips? Yeah, because it comes off. Yeah, you got to readjust it and hook it back on. Mm-hmm. Can you do that for me? Because I can help. I'll help you with it after I finish my live stream if you want. Okay. Okay. I'll be on the bed waiting for you. Okay. Well, I'll fix it for you. Okay. All right. Love you. Love you. Okay. Love you. Close the door. You want your door closed? Yes, ma'am. Please. Thank you. Welcome. All right. So. That was a piece of your email. So in 2025, Luthman posted a video online depicting Mr. Hales as a certain dictator by adding that mustache to his photograph and engaging in the oral with the journalist. The video was published on his trash site, which the image conveyed Israel's personal identification information through his photograph and specifically naming him the URL content. Never consented to that. Now, service history. Mr. Hale's first name, Richard Luthman, as a defendant in the First Amendment complaint filed on April 25th, 2025. There was a summons issued on May 1st, 2025. Made diligent efforts to serve him, including multiple addresses all over the place, including the address that noted at the Staten Island address. The process server reported that the defendant was not known at said address. Give me a minute. Let me make sure that there is not an address. It's going to pop up here. I just want to make sure I don't have an address laying in wait. Give me 1 minute. I'm just trying to make sure. Okay. Let's see one there. On August 17th, 2025, defendant sent an email to Mr. Hale's counsel stating that he did not accept service and demanded strict compliance with Rules of Civil Procedure 4. October 30th, 2025, court denied Mr. Hale's request to serve by email. November 2024, Mr. Hale's moved for extension of time representing the substitute service was being pursued because the defendant was concealing his whereabouts. The court granted that. November 25th. On December 29th, he filed a return for substitute service through the Florida Secretary of State. The third amended complaint alleges that the defendant is a resident of This allegation is based on his declaration of domicile. Yes, he keeps saying, I don't live at these places, but he has a declaration of domicile. So it's a game again. Summary of argument. Defendant's motion fails on every ground. First, substitute service was valid under Section 48.181, which authorizes service on any person concealing their whereabouts regardless of residency status. Defendant concealed his whereabouts by providing inconsistent address information, refusing to cooperate with service efforts despite actual knowledge of the lawsuit, and making personal service impossible. Third amended complaint's allegation that the defendant is Florida resident does not invalidate prior substitute service because Section 48.181 contains no residency requirement where the resident is actively concealing their whereabouts and is engaging in business or business ventures in Florida, and the validity of service is determined based on facts existing at the time of service. Moreover, that same section, also cited by Mr. Hales, applies to Florida residents who actively conceal their whereabouts or evade service. Alternatively, the court should grant additional time under Rule 4M because plaintiff showed good cause and defendant has suffered no prejudice. Second, count 2 adequately states a claim under Section 784.049. The statute defines sexually explicit image broadly to include any image depicting a person engaged in sexual conduct without distinguishing between authentic photographs and manipulated images. The legislative purpose, of protecting victims for psychological harm applies equally to fabricated images. A narrow interpretation would create an absurd loophole, allowing defendants to avoid liability by editing images. The third amended complaint adequately alleges all statutory elements, including lack of legitimate purpose and intent to cause substantial emotional distress. Third, the court has a subject matter jurisdiction because count 2 independently satisfies the amount of controversy requirement. The combination of statutory damages, minimum $10,000, actual damages, $370,000, plausible given plaintiff's substantial social media business, injunctive relief, measurable value for protecting professional reputation, and attorney fees, potentially $75,000 or more, make it impossible to establish a legal certainty that recovery would fall below $75K. Fourth, joinder is proper under Rule 20 because both defendants targeted plaintiff's social media business through a coordinated campaign of harassment spanning 2003 through 2025, and the claims share common questions regarding plaintiff's business, reputation, and damages. Even if joinder, again, was improper, Rule 21 expressly provides that misjoinder is not a ground for dismissal. The proper remedy would be severance, not dismissal. So they're saying, and this was the one argument I'm curious about, which when they look at this, like I said, the one argument I think that they will have to decide on is joinder. Joinder is, will this court look at these parties and say that combining them into this together Is there a reason for them both to be in this, you know? And if not, then do they need to separate this? What needs to happen? Because even Paint Chips, in talking about it, was like, hey, yeah, we may actually have to have this separated. Severance, not dismissal. So argument. Substitute service was proper under Florida law. Alternatively, court should grant additional time. Defendant's service challenge rests on a false premise. The substitute service requires the defendant to be a non-resident. Florida law imposes no such requirement. Florida provides two distinct statutory bases for substitute service through the Secretary of State. Section 48.161 authorizes substitute service on non-residents doing business in Florida or individuals concealing their whereabouts. Section 48.181 authorizes substitute service on any person concealing their whereabouts. Also, the service of process cannot be had. These are separate and independent grounds. The critical distinction is that Section 48.161 applies specifically to non-residents or foreign business entities, while Section 48.181 contains no residency requirement whatsoever. Under 181, when an individual or business entity conceals whereabouts engaged in business ventures in Florida, like Luthman, the party seeking to effectuate service may, after exercising due diligence to locate and effectuate personal service, use substituted service in connection with any action in which the court has jurisdiction over such individual or business entity. The statute's plain language applies to any person concealing their whereabouts, whether resident or non-resident. The factual record demonstrates that a defendant concealed his whereabouts. Let me make sure that we're not going to have an address pop up. I'm trying to do my best to make sure we don't have an address. Whoopsie. You know, they happen. They're in the documents, but Paint Chips is the worst about it. He'll put his address in there for no reason other than sometime, I think, to try to cause problems when people are reading something. The factual record demonstrates plaintiff concealed his whereabouts. Plaintiff made multiple failed service attempts, different addresses in both Staten Island, New York, Naples, Florida. Staten Island address, Dorman stated that defendant was not known at that location. These failed attempts resulted from defendant's provision of inconsistent address information. Most significantly, August 17, 2025, defendant emailed counsel refusing email service, demanding strict compliance with Rule of Civil Procedure 4. This email demonstrates defendant had actual knowledge of the lawsuit and direct contact with plaintiff's counsel. Yet despite this knowledge and contact, defendant refused to facilitate service and provided no accurate address where he could be served. This conduct constitutes concealment of whereabouts. Defendant cannot demand strict compliance with service rules while refusing to provide accurate information necessary to accomplish service. Defendant argues that the Third Amendment complaint alleges that he is a Florida resident and validates the prior substitute service. This argument fails for multiple reasons. First, 181 contains no residency requirement. That statute applies to any person concealing their whereabouts, whether resident or non-resident. Even if defendant was a Florida resident at the time of service, he's still concealing his whereabouts within the meaning of Section 181. Second, the validity of service is determined based on the facts existing at the time service was attempted, not based on subsequent pleadings. That's right. At the moment, like at best knowledge, it's not in the aftermath. That is absolutely correct here. Man. Appreciate you folks. By the way, I see people dropped in a little bit of candy money and some others. I appreciate it. I'll be wrangling some of that for tomorrow. Thank you. Like I said, the little one, or the oldest rather, she is just crazy about that. That freaking, the backroom stuff has been on YouTube forever. So she's like, I've got to see it. That's the greatest. So I don't go to the movies very often. I was like, all right, kiddo, let's go then. She doesn't really, we'll watch movies at home typically because theater-wise, I mean, there's not a lot that I'm like, man, I got to go see that, for myself. But she rarely asks to go see. So I was like, all right, but it'll be fun. We'll have a dad-daughter day out. And the little one, she's going to go to grandma's and have her own day out. So I think that's great. They both get their own days, I think that's awesome because they both, a lot of times they end up doing stuff, as a tandem. And it'll be nice that they have their own days. But anyway. So let's see. When plaintiff sought and obtained the court's extension for substitute service November 2025, plaintiff counsel acted in good faith based on information available at the time. Third, the inconsistency in residency allegations itself demonstrates concealment. Defendant filed a declaration of domicile in Florida, May 2022, yet provided address information suggesting New York residency. This inconsistency made it impossible for plaintiff to determine where defendant could actually be served. Plaintiff complied with all requirements for substitute service under 181. The statute requires that the party seeking to effectuate service exercise due diligence to locate and effectuate personal service before using substitute service. Plaintiff satisfied this requirement through multiple service attempts at different addresses over several months. Plaintiff filed substitute service return on December 29, 2025, demonstrating compliance with procedural requirements. The Florida Secretary of State accepted service. Again, it goes through all dogs. Alternatively, they're saying here, I don't think we need another time argument. So we will skip over a time argument because we've seen this case has been rife with these. If you want to, and you should read every piece of a document, but I'm making sure that it's on your screen here. You can go through, but it's asking, it's like, hey, if yet again, if you're saying that service is not correct, then you need to let us serve. So that's what this is about. It's talking about the factors that maintain that. After a while, though, I'm telling you, to have this person dodge service as much as they have, if a judge comes back and is like, well, actually, it's like, no. Just the way that this has been allowed to roll with services is insane. But you can see all of this is an argument over more time. I'm slowing it down so you can capture any of that argument if you want. But I don't believe that we need to go over that. So here too. Then we go to count two. Okay. So count two adequately states a claim under Florida statute section 784.049. Defendant's motion to dismiss count two rests on the strained interpretation of Florida's sexual cyber harassment statute that would create an absurd loophole. Under defendant's reading, a perpetrator could avoid liability simply by editing an image to make it false, even though the harm to the victim is identical or worse. This interpretation contradicts the statute's plain language, defeats its remedial purpose, and finds no support in the law. The statute's plain language covers edited and manipulated images. Section 049 defines a sexually explicit image as any image depicting nudity or depicting a person engaging in sexual conduct. The word any is expansive and unqualified, encompassing all images that depict the specified content. The statute does not distinguish between photos and digital creations, between actual images, edited images, or between real conduct and falsely depicted conduct. Had the legislature intended to limit the statute to authentic photographs of real conduct, it would have used narrower language. Instead, it used the broad term any image. The statutory definition of image reinforces this breadth, stating that the term includes but is not limited to photograph, picture, motion picture, film, video representation. This use includes but is not limited to demonstrates legislative attempt to encompass all forms of visual depictions. The term representation is particularly significant as it encompasses depictions that may not be photographic in nature, but still represent a person in a sexual, explicit manner. The statute uses the word depicting to describe the relationship between the image and the conduct. To depict means to represent by a picture or to portray. The word does not require that the depiction be accurate, authentic, or truthful. An edited image that falsely depicts plaintiff engaging in oral is still an image depicting a person engaging in the sexual within plain meaning of the statute. The legislative finding in 0409 identifies that the harms that the statute seeks to address. The legislature found that when sexually explicit images are published on internet websites without consent, they create permanent record, causing significant psychological harm and can be viewed indefinitely by persons worldwide. These harms are equally present, if not greater, when someone publishes a false sexual explicit image, a victim depicted in a fabricated image like that may suffer even more severe harm because the image is not only humiliating, but also defamatory. That's true. Defendant's narrow interpretation would create a perverse loophole. A defendant could avoid liability by editing an image, making it false, even though the harm to the victim is identical or worse. Legislature could not have intended this result. That's right. You know, when you look at it, I think the statute is pretty clear in its meaning. It did not mean that somebody could just go out and, again, you think about the argument. The argument is, I believe, is a good argument because what it's saying is under that, all a person would have to do is take a real image and do something to said real image and be like, well, that's not actually a real image, you know? So they could publish a real image, only they could make a few changes to make it a quote unquote not real image. You can see how absurd that notion would be. And that's his argument. Oh, well, it only encompasses real imagery. Said even they know that these, again, any of these morons, when they talk about statute, again, like look at all of them. Not that anybody would want that, but you look at like Miltos, for example, take that guy. Do you think that his first experience with a woman, he would want that to be in a picture like that? No, of course not. Do you think that, do you think any of the females out there would consider it appropriate if one of them was broadcast in that method? Absolutely not. They call the police so fast, they make your head spin. They know it's a problem. They absolutely do. But it was done to another person, so they don't consider it a problem. The things that they call harassment more are amazing, considering what they themselves engage in. And then to try to say that this wouldn't be something that they would note as harassment and more. Now, again, the argument is going to have to be what the courts actually will allow a person to have to put up with. I have no faith whatsoever in courts, so we will see. But I believe the statute was not created to allow absurd loopholes like that. Because if they were, again, it would be so easy to manipulate that and to work outside of the framework of it. And in this day and age, when you have deep fakes, you telling me that you can't sue over a deep fake though? You telling me that you can just do whatever? Because that's essentially what the argument is. Well, a deep fake, that's not a real image. You know, somebody made it in Chat GPT or something, you know. Actually, you can't make it in Chat GPT, but you know what I mean. If they made it in AI, well, that actually that wouldn't actually be them, therefore. It's kind of an insane argument when you get down to it. So, the complaint adequately alleges all statutory elements. Now, to survive the rule to dismiss, a complaint must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Again, you can see some pretty basic casework. The court construes all allegations as true, draws all reasonable inferences in favor of the plaintiff. The third amended complaint adequately alleges all elements of sexual cyber harassment. First, the complaint alleges that the defendant posted video depicting engaging in the oral with journalists, that this image depicting the person engaged in sexual conduct satisfying the statutory definition. Second, the complaint alleges the image contained and conveys plaintiff's personal identification information through plaintiff's photograph and by specifically naming plaintiff in the URL and content. That under 784.049 defines personal identification information as any information that identifies a person, including any name or unique physical representation, so that the allegations survive or satisfy this requirement. Third, the complaint alleges the video was published at a specific internet address. This satisfies the requirement that the image be intentionally published to an internet website. Fourth, it's been published a lot of other times too. Fourth, the complaint alleges that plaintiff consented to publication, did not authorize, approve, or give permission for the publication. This satisfies the consent requirement. Fifth, the complaint alleges that the images were posted to harass and defame plaintiff, that the publication served no legitimate journalistic, educational, or lawful purpose, and paint chips had no relationship with plaintiff that would justify publication. The publication was not newsworthy. These allegations, accepted as true, plausibly establish that the publication was made for no legitimate purpose. 6, the complaint alleges that prior to publishing that, again, he sent emails making false allegations that plaintiff was anti-Semitic, comparing plaintiff to advocates of eugenics and mass murder. The complaint further alleges that the publication was designed to humiliate and distress plaintiff, and that defendant knew the publication would cause distress. These allegations plausibly establish intent to cause substantial emotional distress. A defendant who first sends harassing emails falsely accusing the plaintiff of anti-Semitism and comparing him to advocates of mass murder, and then publishes a sexual explicit image depicting the plaintiff plausibly intended to cause substantial emotional distress. C, the First Amendment concerns are unfounded. Section 049 requires proof that the publication was made for no legitimate purpose. This element protects legitimate journalistic, educational, artistic use of sexual explicit imagery, true parody, or satire. Serving a legitimate purpose would not violate the statute because such uses would satisfy the legitimate purpose element. The statute thus contains built-in First Amendment protections that prevent it from reaching protected speech. The complaint alleges that the publication serves no legitimate journalistic, educational, or other lawful purpose. This allegation, if proven, distinguishes this case from situations involving protected speech. The statute does not prohibit all publication of sexually explicit images. It prevents publication without consent, no legitimate purpose, with intent to cause substantial emotional distress. These limitations ensure that this statute targets only unprotected conduct. The complaint alleges that the publication was designed solely to harass and humiliate the plaintiff, adding a certain German dictator mustache to a sexual explicit image depicting plaintiff does not transform the publication into protected parody. The First Amendment does not protect the creation and publication of false sexual explicit images for the sole purpose of harassing and defaming the depicted person. Now, damage wording is immaterial. The prayer for relief seeks $370,000 or $5,000, whichever greater. When the statute provides for $10,000 actual damage, whichever greater. This is again, it's a typo. That's what it's telling you. A typo doesn't matter, you know. The typo doesn't matter. The complaint, substantive allegations seek actual damage of $370,000 based on specific harm, including harassment, fear, embarrassment, lost opportunities, strain on relations, and expenses. 3, the court has subject matter or jurisdiction over count 2. Federal courts are courts of limited jurisdiction. In order to invoke a federal court's diversity jurisdiction, a plaintiff must claim, amongst other things, that the amount in controversy exceeds $75,000. The party invoking federal jurisdiction bears the burden of establishing the amount in controversy of $75,000. However, to justify dismissal, it must appear to a legal certainty that the claim is really for less than the jurisdictional amount. Count 2 independently satisfies the amount in controversy requirement through the combination of statutory damages, actual damages, injunctive relief, and attorney's fees. .049 provides damages of $10,000 or actual damages incurred as a result of violation, whichever is greater. The statutory framework establishes a minimum recovery of $10,000 if liability is proven. Third amended complaint seeks a greater amount. It's $370,000, but the statutory minimum provides a baseline for the amount in controversy calculation. So actual damages allegations are sufficient and plausible. So the third amended complaint alleges that plaintiffs suffered multiple categories of damages as a result of defendant's sexual cyber harassment, including harassment, fear, extreme embarrassment, loss of professional opportunities and prestige, strain on personal relationships, prolonged expense, and inconvenience. While these allegations are stated in general terms, they are sufficient at the pleading stage for jurisdictional purposes. The distinction between pleading requirements and proof requirements is critical. Plaintiff is not required to provide an accounting and detailed quantification of damages in the complaint. Courts analyze the amount in controversy based on the allegations in the complaint and reasonable inferences therefrom, not on detailed evidentiary showings. The plausibility of $370,000 in actual damage claims must be assessed in light. I heard you coming.
Zelda.
Yes, I know. I heard you coming. Actually, I can't play right now. I'm reading the document.
Yeah, but I see you were playing Zelda.
I was, yeah. But I can't while I'm reading the document.
Hey, everyone.
Hey, well, hey, this stuff, though. Hey, are you going tomorrow?
Yep. Are you going and I can't wait to get my phone back.
Well, hey, you need to go upstairs, okay? Because I got to go over this. It's not kid friendly in any way, okay? Love you. Close the door. Okay. I've been trying to work out a thing where when she comes down for something, again, she can't hear or she doesn't see the dog. She can read all of that anyway. She wouldn't understand what we're talking about anyway, but I'm trying to work out a thing where if I'm like, this is not friendly, you cannot be around, you can hear this. Like, okay. It's a weird, delicate balance, you know? Trying to figure out how to cover Anne. Oh, anyway, let's continue. So, the plausibility of $370,000 must be assessed in the light of plaintiff's unique circumstances as a social media influencer. Plaintiff operates What the Hales, again, so you go through, again, how he makes money. Because they're talking about the $370K, how that could scale. We've seen these arguments on other things for advertisement dollars, how money comes up. You know. So again, the argument is that for statutory minimums, essentially Paint Chip's argument was there was a typo in there, therefore I'm going to leap on the typo. And I don't blame a person for trying to leap on the typo, but it is a typo. So it wasn't a question of legitimate damages that you could you could attach and say, hey, It was, oh, that guy said a number, it doesn't qualify. And you can tell the way that it's worded that it's just a mistake. And mistakes on their face, they happen. Man, lawyers, Lord. you saw a bunch of actually, you've seen paint chips filing. He'll have typos in them as well. He'll have some that are that are quite funny sometimes. They all do, but sometimes they pop in at inconvenient times. But that's why you go over the filing is supposed to be taken as a entirety. The entire document itself. It's not supposed to be taken as a, oh, look, I found this one word, therefore gotcha. If you could do that, you could probably pull apart most, not every, but you could pull out most legal documents in some way. There's a lot of that. So the injunctive relief adds substantial value. So 049 expressly authorizes injunctive relief. The Third Amendment complaint seeks an injunction requiring paint chips to remove those images and destroy all copies. When a plaintiff seeks injunction or declaratory relief, the amount of controversy is the monetary value of the object of the litigation from the plaintiff's perspective. That's interesting. The value of the requested injunctive relief is the monetary value of the benefit that would flow to the plaintiff if the injunction were granted. The value of declaratory or injunctive relief must be sufficiently measurable to certain to satisfy the amount in controversy requirement. The requirement is not satisfied if the value of the equitable relief is too speculative and measurable. It is a matter of degree. Here, the value of injunctive relief is, one second. Yes. Huh? Ask Sissy to crunch it, please. Okay. Close the door, though. Thank you. For a social media influencer whose entire livelihood depends on his online reputation and public image, the removal of explicit images from the internet has clear monetary value. Yes, when they're created, in fact, you could say, why are these things, again, are they intended to just destroy your reputation? Are people that have perhaps had financial crimes before, are they intended to shake you down? Don't know. The benefit flows directly to plaintiff in the form of protections for his professional reputation, preservation of business relationships, retention of sponsors and advertising revenue, maintenance of subscriber base. The case is distinguishable from cases where injunctive relief was deemed too speculative. In here, for example, the court found the monetary value of injunctive relief prohibiting allegedly misleading advertising was too speculative and measurable to establish the requisite amount in controversy. There, in connection between injunction and any monetary benefit to the class member, annuated and uncertain. By contrast, the connection here, it's direct and measurable. Removing sexual explicit images of plaintiff from the internet directly protects his ability to maintain his business relations and revenue streams. For someone with, again, all of those numbers, monetary value of protecting reputation could easily be substantial. Attorney fees. So attorney fees, it talks about also. So this is the argument that is saying that with the amount that attorney fees also would be part of that. So that's that again, you can look at the argument for that. But it's saying as far as money, again, you've got a few arguments that are being thrown, they're being answered, let's say. Cumulative effect defeats legal certainty. The amount of controversy analysis must consider all components of potential recovery: statutory damages, actual damages, so you can see the numbers through there, injunctive relief, and attorney fees. So when you put them all together, this combination, right there. These components makes it possible to say with legal certainty that the amount of controversy is below $75K. Each component is independently supported by the allegations in the third amended complaint and statutory framework. Together, they establish that defendant has not met his burden of showing legal certainty that plaintiff cannot recover more than the jurisdictional threshold. Now, joinder. Now, this, again, is an argument that was thrown in. This is one argument that I am curious about, for sure. So, joinder, again, why is Lynette Preston and paint chips, why are they in the same filing? How is it appropriate? Not from what you know, but from what's being pled. How are these two things, how are these two people, how are they judged together in a case instead of having this, again, separated, severance? So Rule 20A permits joinder of defendants if any right to relief is asserted against them jointly, severally, or in the alternative respect to or arising out of the same transaction, occurrence, or series of transaction or occurrences. Any question of law or fact coming to all defendants will arise from the action. The 11th Circuit construes Rule 20 liberally to promote trial convenience and expedites the final determination of dispute. So the claim arises from the same series of transactions or occurrences. Both defendants targeted plaintiff in connection with the social media influencer business. Defendant Preston was a viewer, fan of What the Hale's platform before turning against him when denied access to fan base for fundraising purposes. Preston's defamatory campaign included road signs, social media posts attacking plaintiff's reputation. Preston filed a stalking case against plaintiff, which was part of her campaign to harm his reputation, extract money. Paint Chips sent emails to the ADL YouTube channel that covers plaintiff making false statements about plaintiff, posted sexual explicit videos targeting his reputation. Both defendants' conduct was designed to harm plaintiff's reputation and interfere with social media business. This common target and common purpose support joinder. Oh my God, man. You know what this would mean if it actually went forward? Oh, paint chips, paint chips, paint chips. I get to talk about you on the stand, baby. Because you all would want to talk to me. Wouldn't that be fun? Wouldn't that be fun? See, he made this severe mistake of when he went out and did all of this, that I have some kind of problem with people knowing who I am. People already know who I am, buddy. Didn't do your research there. So I would be happy to make sure on the record, putting all kinds of wonderful things. All kinds. But again, you have to get that far. So we'll find out. But his emails and publications occurred January 2025. Shortly after Preston's stalking case was dismissed, both defendants' conduct occurred during a continuous period of attacks on plaintiff's reputation. Common questions of law, in fact, exist. Rule 20 requires any question of law or a fact common to all defendants. This is a low bar. Only one common question is required. Multiple common questions exist here. Factual questions include the nature and the scope of plaintiff's social media business, its reputation in the community, the harm to plaintiff's business from reputational attacks, emotional distress, and the extent of damages. Legal questions in Florida law on damage to reputational harm, standards for emotional distress damages, and calculation of business losses. Misjoinder is not ground for dismissal, even if the court finds joinder improper. Again, they go through the federal rules. Their procedure 21 expressly provides that misjoinder party is not grounds for dismissing an action. The proper remedy is severance, not dismissal. Defendant's motion seeks dismissal, which is not authorized by Rule 21. At most, courts could sever the claims into separate cases, but both cases would continue. Severance would be inefficient. That's right. They love efficiency. Severing would require plaintiff to prove the same facts twice, nature of business, reputation, damages in 2 separate trials, severing risks, inconsistent findings about plaintiff's damages and credibility, trying both claims together, conserves judicial resources, avoids duplicative proceedings. Neither defendant has shown how joint trial would prejudice them. They can present separate defenses, cross-examine witnesses. Any minimal prejudice is outweighed by the efficiency of joint trial. Florida anti-SLAPP does not apply, does not provide an independent basis for dismissal. Defendant invokes Florida anti-SLAPP statute and seeks to preserve substantive protections and fee-shifting remedies. To the extent defendant seeks a dismissal under federal rules based on anti-SLAPP principles, the argument is subsumed in Rule 12b-6 motion and should be rejected. To the extent defendant seeks fee shifting, if he prevails, the issue is premature and should be addressed only if he prevails on the merits. So conclusions. For the foregoing reasons, plaintiff Jeremy Hales respectfully request that the court deny defendant Paint Chip's motion to dismiss third amended complaint, motion to quash service, alternative motion to sever incorporated memorandum of law in entirety. Specifically, plaintiff requests the court deny the motion to quash service under Federal Rule of Civil Procedure 12b-5 because substitute service was properly effectuated under 181. Alternative, give more time. Deny defendant's motion to dismiss count 2 under Federal Rule of Civil Procedure 12b-6 because the third amended complaint adequately states claim for sexual cyber harassment under this section here. Deny defendant's motion to dismiss under Federal Rule of Civil Procedure 12b-1 because the court has a subject matter jurisdiction over count 2 based, again, on the amount in controversy exceeding over $75K. Deny defendant's motion to sever under Federal Rule Civil Procedure 2021 because joinder of the plaintiff, defendants Preston and Luthman is proper, or alternatively, if the court finds severance appropriate, order severance rather than dismissal. Deny defendant's request for relief under Florida anti-SLAPP statute as premature and grant whatever else that they deem appropriate. So there you have it. 30 pages, baby. Wow. That's it's interesting when you go through that again. Count for Fed 2, what's left again? It's pretty straightforward on on what remains. Now again, I don't know about joinder arguments. Again, if the that is one that I'll be curious how they'll address that. They may say, hey, all these attacks on that, plus they relate to this person right here, reputation, etc., so it is proper. Again, don't know. But it would be good. It also, I do believe that as far as the statute that they quote, as far as the sexual imagery is concerned, definitely, as a legislature, did not intend to leave open something where you can just be like, oh, well, this actually, this doesn't deal with this. Why? Because, well, it's not a real image. That is not what the law intended with that at all. So for them to try, for him to try the argument with that, but it isn't what the law states. It's what the judge says the law states. So we will see. Anyway, let's hit some super chats. Let's do that now. 1 second here too. Let me check something real fast as well. That's so funny. Somebody mailed me and said that that the engineer was just J-Hip. That's working on everything. He's a train conductor. That's the wrong kind of engineer, damn it. Yeah, Jaguar, thank you for that 20 gifted memberships to kick this off. That is awesome and much appreciated. Thank you, my friend. That's awesome, man. There have been so many gifted memberships in here. Love it. Stacy dropped 10 gifted memberships. Look at that, 30 gifted memberships off go. That is awesome. Thank you there. We also had Adair dropped 5 gifted memberships. Man, Adair, how you doing, by the way? Good to see you, my friend. Cindy dropped gifted membership too. Thank you, Cindy. That is awesome too. Max Lab, thank you for your super chat as well. Thank you, Max Lab. I have my favorites. Hey, thanks for the 5. Thanks for the birthday wishes, everyone. Having a great birthday. I have plans. Only here for a minute. Have a great night, y'all. Well, you know what? If you catch this later on, because I am my favorites, appreciate the heck out of you. And
Happy birthday from both of us to you. Happy birthday.
Happy birthday.
May all your dreams come true. Happy birthday. We love to have you here. Happy birthday. Here's to another year.
All right. I love it. I hope your birthday has been amazing, by the way. And remember, as I say with everyone, if for some reason you're like, could have been better, you get a do-over. You get that one do-over card. Now, for multiple do-overs, I don't know about that. You'll have to consult the rule books. But you get one for your Sailor Dog Jupiter. Thanks for the 2. When Megan's away, chaos will reign. That's right. You know, I meant, by the way, I was going to go over, as I said, the motion for protection from Lips, talking about us, not wanting us to be able to talk at all about her and our own lawsuit. But we've had so much stuff, I haven't been able to get to it yet. Now, that doesn't mean I won't. Tomorrow, like I said, I'm not sure about tomorrow. I'm going to leave that up in the air. But I'm definitely not. Usually, if I go out or do something, I make sure that I get back within X amount of time. Tomorrow, I'm not hurrying in any way, shape, or form. So, if any story will wait. But I was going to do that with Rumble today, and there was something wrong. What I wanted to do is I wanted to show you 2 things. I wanted to show you that, but also I think since we're seeing all of this stuff with the bankruptcy, I think going back and talking about when a certain lawyer got in trouble and had a bunch of judges, talking about this dude, what's up? You're an idiot. I think that hearing is amazing. And I thought that would be fun to stick over with the Rumbles, but I didn't have a chance today, but we'll get to it. Venomous Venoms, thanks for the 2. Her lawyer asked for 30 days on 430. No mention. Well, they keep playing games. They do. They play games all the time. And ultimately they want delays. Like I was saying the other day, they bragged about a 5-month delay with Bruce. That was his win. He bragged about it. So their intent, and they bragged about how the bankruptcy will delay other cases and will cause this or will cause that. And it will create financial issues. They know that doing all of this creates more financial burden on a person that already has spent a lot of money in the courtroom. So they know. Aubrey, thank you for the gifted membership as well. Thank you, Aubrey. That is awesome of you. Much appreciated. Thank you. Grammy, thank you for the 16 months. I need to stop saying, how dumb can these two get? I swear they take it as a challenge. I know that when I say this is the stupidest thing, or, you know, how stupid can a person be? I really do feel like some people do take that as a challenge. They're like, well, I can be dumber than you think. It's like, no, I didn't mean it that way. Stop, please. Actually, I like seeing how dumb a person can be, to be honest. I'm very proud of them. Because it takes a lot. With the internet these days, it takes a lot to surprise somebody. Have you all seen the... so it's trending now, but this came up... it came up, God, weeks ago. Maybe longer. Did you all see the woman that got pulled over for texting? She gets pulled over. I shared this on Twitter if you're over there as well. So this woman gets pulled over, and the police officer tells her that she was texting with her right hand. The only problem is, and they're very adamant about it, the only problem is the woman doesn't have a right hand. She only has one hand. The cop still goes and writes her a ticket. And it is only dismissed after public ridicule and embarrassment. The DA was going to go forward with this and try to prosecute. She's like, I couldn't be on my phone texting. You know, how would that work? And, you know, a lot of people were laughing about it. And my problem looking at it was, you know, when you look at this, it's all funny until you realize that these are people that could take your life in a heartbeat. They have weapons, and they're not just dumb as mud, but they're dishonest. That's dishonesty. If a person does something like that, they should. You know, again, did they make a mistake? Maybe. But they didn't try to remedy that mistake. They decided to double or triple down on that mistake. And that's where the dishonesty portion definitely comes in. It proves it to me. I think that should remove them as far as law enforcement. They should not be allowed to go out and to ever be law enforcement again. But that's crazy, isn't it? Right says, what's up? Thank you for the gifted membership there. Thank you for that. It's much appreciated. Thank you. Hello. Like I said, gifted memberships are awesome. One of the greatest features on any platform. Because again, it's not the method, it's the message. And the message is saying, hey, you are definitely part of whatever goes on this place. We appreciate and value you. And it's said by the people that back the platform. So thank you. SF, thanks for the 10. It's bad either way. You either did it months in advance, didn't tell the court, that's for scheduling, or you did it after and didn't make sure it wasn't on your court. Yes, exactly. Well, on top of that too, to blame opposing counsel for that is so just flagrantly dishonest too. You know, her counsel took part in that. And then of course, they're like, no, I didn't. And then it kills me. That level of dishonesty, that bothers me. You know, because, I mean, again, it was mailed to them. It was brought up. They 100% knew about it. It just makes you wonder, are we trying to have a bankruptcy and get all of this stuff taken care of? Or is this delay tactic? And when you start answering those questions, that's when it gets more, you know, down to the, Again, I'm not the one answering that question either. Maybe they could answer that question, you know? Because I think it's a very legitimate question. Especially, again, when you get down to just the way that that came up. It's just so dishonest, man. These people always. Blue Eyes dropped at 5 giftos there. Thank you, Blue Eyes. Again, I can't say it enough. The gifted memberships. I'll have people write and be like, I don't know who gave me a gifted membership, but man, I appreciate the heck out of that. That is so awesome. You know, a lot of times it'll make people's days. So I think that's why, like I said, I think it's a great feature. And thank you folks that promote that. See, Photo Lady. This was great too. Hey, Tug and Chad, I'm excited to announce the birth of my great granddaughter. That's awesome. Today, 4:30, 5 pounds, 13 ounces. She's beautiful. That is so beautiful too. You know what?
Happy birthday.
Man, that is awesome. From all of us
to you. Happy birthday. May all your dreams come true. Happy birthday. We love to have you here.
And then it's
Happy birthday.
Here's
to another year.
Oh, it's proud there. I love it. I love it. I love it. I love great news. Said. And also, Photo Lady said, hey, thank you to everyone. Appreciate you. Hey, we appreciate you. And that is great. Uriah, you started cheese on my feet. Cheese on my feet. Oh, that's so funny. Cheese on my feet. That is really funny. I love that. You folks are funny. I like that song, but I like cheese on my feet. That's really funny. It's probably more comfortable than trying to wear J on your feet. You know? Cheese on my feet. Oh, shit. That is funny. William, thanks for the 10. I bet she dodged the depot because the feds coughed out money for an engineer. Yeah, we'll see. We will see. You know, I mean, again, the amazing question, and it was supposed to be answered under Florida statute, is how much was raised? What exactly is it used for? You know, again, if you go through the statutory requirements of Statute 496.411 and 496.413, they lay out very well the requirements for raising money, and a call to do something like the projects. You don't have to use the words like charity or fundraising. You don't have to use any of those. Helping a family in need. Also calling for the building project. That meets the statutory requirement. Now, typically you could get away with it with two things. You could either give all the money straight away to Preston by, say, putting it in a GoFundMe, giving it all to her right there. Or you could alternatively, you could say, well, we're too small to be a real charity. We're just independent people out here doing nothing. But the problem is that they made over $50,000 in one fiscal year, 2024. They talk about it. They argue with a person about that. You know, they argued. And that was just one donor. Again, there were multiple donors. So they did not provide any amount proof whatsoever, and they refused to, not just to donors, but anyone. That is supposed to happen under that statute. They are required within 14 days. When donors started asking for that, they're supposed to provide numbers on how much was raised, what the expenditures are, and more. They also said that if nothing happened by a certain date, they were going to refund all the money. That didn't happen either. So again, when people are like, you know, even if they provide it, is that everything? Is that all of it? As I said before, if you gave me 10 grand and for a project, and I put, they're also under Florida rules with fundraising. The stuff talked about using it how you want. It's a gift. You can't keep any of it. It's not yours. You have no requirements. And in fact, they should have already turned the money over to Preston by now, because while there is no specific rule stating how long money could be held, for the permits for the project to be something that they could not complete, the money belongs to the person that you raised it for. It doesn't belong to you. And it also, to be honest, with refunds, I guess they could have refunded, but Preston could have potentially sued them for that too. They should have turned the money over to her in total with an accounting of it. And as she noted, they didn't. They also, there are rules about how you situate money. Not just about how you keep it, but there are trust rules. There's all kinds of rules for it. That's why when they were like, we're going to take people to court because of X, Y, and Z. It's like, holy shit, have you read the statutes on that? Have you ever read the statutes on it? One of these fucking donors is going to get smart one day and they're going to read them all. They're going to stop asking people that are outside of it for help, and they're going to fucking do it themselves. And when they do, that's when there'll be a problem. But a court can actually authorize, if you look at the statutory requirements, a court can authorize that you have to provide all of that information. The information you said you don't have to provide, but you do. And it's not just to donors. It's pretty interesting stuff. You look it up, Florida Statute 496, but specifically 496.411 and 496.413. They all deal with charity. But anyway, hoping that if work starts, you can get a homestead exemption. Yeah, you can't actually do that, but I believe it's based on the date. It is. It's based on the date the bankruptcy is filed. They cannot get an exemption after the fact. That is expressly noted too. So they would essentially be working on something that, if that is their purpose, if they think they can do it because of that, that would not be the case. They also haven't asked a question too in the bankruptcy when they're talking about land and what land is what. Well, you might get into some interesting arguments there too over what land you have to sell. But I digress. The interesting thing in that too is when they talk about that, they blame other people for them potentially losing their land. Nobody else rooted for their land loss. Other people told them to go the bankruptcy route where they do potentially lose land. Other people did not tell them to go that route. In fact, we told them to do the opposite. Bankruptcy is a crazy notion. It's funny because with their bankruptcy method for this too. If they thought, man, me doing this, I can get away with all of this stuff. Have they ever thought what that would mean for anything that they do? Of course not. Becky, thanks for 15 months. What a horrible person. Paint chips. Need to go back to jail to see Bubba with the dropped soap. Fun times, right? Andre dropped two there for Candy Money. Thank you, Andre. I'll tell her you too, my friend. Appreciate you. Thank you, Andre, as always, my friend. Poindexter, thanks for the 50 there. For the ferments, you don't have to pull. For the motions, you don't have to write. For real. Excuses you don't have to make for the fundraisers. You don't have to organize for all the content. You only have to share. Here's to laughing at them all. Thank you. Yes, indeed. Indeed. You know, laughter is the best medicine, too. I love it. I love that. I love the Z Vomit and Z Paint Chips had a live stream to cry over the fact that, again, he wrote an article where Vomit did, where he gets a woman arrested. He talks about that. And then he cries about the fact that, oh my God, they said I did it. Now, you said you did it. Does the woman blame me? Well, she should. She should. You know, holy shit. You leaked a freaking confidential court record. My God. She lost her lawyer over it and everything else. If she doesn't blame you, dumbass, you know, she absolutely should. When you bring in people, again, don't ever, if you are in the middle of a contentious thing like a divorce, get good lawyers and take their advice. Don't buy into the advice of people that it feels like the, you know, in the moment, it fulfills this base want for revenge. That's what these assholes will try to sell you. They'll try to sell you that. And all that does is ends up fucking you in the long run. If I would have gone with something like that, I wouldn't have my kids. You know? There were many times I wanted something like that, but it's not something that you actually want. You know, you think you want it until it costs you everything. And then you're like, well, I didn't really want that. So, yeah, I love to be able to laugh at them all. Emmy, thank you for the 16 months. Thanks to Tuck and Mods for all you do. Well, thank you. Yes, Mods, love you all too. Appreciate you all. Because I make the Mods job harder sometimes. I do. I appreciate them. They're good people. Very good people. LaWanda, thank you for the 5 there. Popcorn for your father-daughter movie day. Well, thank you for that. Appreciate it. Yep. I'm sure we'll be popcorning up. I'm going to take her to, I'm going to take her out to eat. I'm going to take her by a couple of places. You know, we're just going to have a day out. I'm going to take her to the movies. We'll make a day out of it. I think she'll have fun. You know, just goof off. Have a good one. Sean, thank you for the 20 there out for your father. For your daddy-daughter movie day. Have fun. Thank you. Thank you very much. I said, I typically, it feels so weird to skip days. You know, not to have a day on. I work, you know. I like doing this stuff anyway, but man, it's so funny to see the oldest like that excited about something, like really wanting to see a movie or something. I think it's good. It's been a minute. There was a horror movie at one time that she was excited about a while back that we watched. I can't remember what it was. Lord, I can't remember what it was. She was like, please, I want to see it. So we ended up, but it's been a minute. So I think this will be fun. Andre, thank you for the 5 there. If anyone has a way to contact Mozilla besides email, please do. It's been seen in 6 days. Many are worried. Oh man. Hey, yeah, if anybody knows, just noting again, Rizilla, if Rizilla's okay. That would be something. Just a note. Or if Rizilla catches this, if you're out there, hopefully, you know, just out there doing your own thing. But I just let folks know. And let me know, too, in the aftermath, even if I don't hear about it. Thank you. Tree God, thanks for the 2. Get a screen distortion cover like medical offices. Yeah, I actually have one of those for one of my laptops. Took me a minute. Robin, thanks for the 10. Put towards your movie day. Thank you, Robin. That is awesome of you too. Thank you very much. Appreciate that. Janice, thanks for the 20 for Lug and Buck. I sure do love these girls. They're the cutest. They're the funniest. You're a great father. Thank you. It's no wonder why we have girls. Are so awesome. Yeah, I appreciate you saying that. They are good kids. They are. They're funny. They're nuts. They're so funny. Hey, Paul, I saw your thing. Did you record any of that, Paul? Hey, write me back. Let me know if you recorded some of that. That would be amazing to see the po-po coming out. Yeah, the bricks and minifigs thing is crazy if you've not heard about that. It's essentially the theft of $200,000 worth of Legos from a family by a company whose now their corporate offices are they're trying to pretend, oh well, that was just this one store and it doesn't reflect on us, but it kind of does. Yeah. So Paul was noting, putting up a review, and wow, that's interesting. I'm curious about hearing more about that. Mary Beth, thanks for the 4 months. Tug, do you think part of the reason why she's doing all these delays is so the court will dismiss the bankruptcy case? Is what BBB wanted. I think that they wanted to dismiss the bankruptcy case already. That's something that she told Tina. They wanted it dismissed already, but they couldn't get it dismissed. They're on the hook for it. So, unfortunately for them, they're locked in. They picked up all of these. Again, you get to a certain point and it's like, well, too little, too late. So they seem to be at the too little, too late point, Too bad for them, right? But yeah, I think the delay stuff is about costing Hale's money. I think that's been one of the primary, and courts are not supposed to get, but at the same time, like with a doctor's appointment, they typically don't run into people who misuse these things. It's just like Laura Owens, for example, taking a different kind of case, but still, talking about misuse. All right. We asked the question, why a court would not have that, like, why can a person come in with a false pregnancy petition and be able to, to get away with that? Why is that set up where you could do that? And the thing is, it's because courts, they don't expect the misuse, which they should. They absolutely should, because they should be protecting anybody that's attached to it. But unfortunately, people, when they misuse these setups, again, they're not really set up for that. They don't detect it so well sometimes. And that is a failure on the part of court systems. They allow other people to be financially victimized. I don't know any other way to put that. I think it is financial victimization. If you allow people to sit out there when they're trying to seek justice, to try to run from claims, to try to bleed wallets. It's absolute insanity. I do wonder, though, if Preston, if she thought this is the way things would play for her. She also talked about sending out cease and desists. And it was like, man, you did. I hope you tell your lawyers that you asked us to cover this. And again, that'll be a lot of fun. I would really look forward to a case if you want to play that game. Any of these people, when the Fats are talking about cases, I think that's interesting. When they're talking about it, making threats, a lot of these people make threats. But if they, You notice they keep talking about how now they're going to sue Megan. It didn't become Megan and Tug. Because like I said, they know they fucked up with some claims. But they need to understand they made some pretty horrendous claims about Megan Fox, too. She needs to dig them all up. Janice dropped 5 gifted memberships as well. Thank you, Janice. That is awesome of you. Again, you folks have made it rain some memberships, and that is awesome. Thank you. I love it. Thank you for that. Hey, what's up? Thank you for the 44 months. That's wild. Taking my boys and their cousin to see Backrooms tomorrow too. Heck yeah, they're driving me nuts. Should be a good time. Enjoy love all y'all. Well, indeed, I think I like the idea of the Backrooms. I like that original short video. If people have never seen it, like that original is good. Now, all the other lore and stuff, I don't know. There's just so much of it. But the original, I remember the original when it came out. I thought the original was actually pretty good. And it's interesting if it makes as much money as predicted and it becomes the #1 movie for the week, which it looks like it will, then you'll have a 20-year-old, the youngest guy ever, to have that #1 movie spot. It's wild, isn't it? Now your Bizwax, thank you for the gifted membership there. Thank you. That is awesome and much appreciated. Oh, and Janice, thanks for the 5 there. Any updates on that? Well, you know what? That is a really good question. Let's check it. You know, I've actually got it right here. Give me 1 second. Glad you asked. We can pull it up here. We can do a little of the old refresh room. Boom! $3 still. Sorry. Isn't that amazing? I'm telling you, if maybe you should hire some people like myself. $3. Oh my, oh my, oh my. $3 freaking dollars. But that's all he's managed. $3. You gotta admit that's pretty funny. All that for what? All right. I'm gonna call it a day. I appreciate you folks again. Oh, I'm not sure who's live right now. What's today? Thursday? Oh, Shizzy. Is Shizzy? No, wait. Shizzy, is he away? I don't know who's on right now. Who's on right now? Let me look. Let's see if we can send people to. I haven't checked. Y'all can find people. I'm going to leave. I appreciate you. I got to go fix something real quick.